All right, so my name is Camila English. I am an attorney at Daunting KCMS Alores. Um, I've been a practicing attorney for 7 years. It will be 8 in November. I've been in probate and guardianship law for the last, I want to say, last 6 years, 5 to 6 years. So today I'm going to talk with you about preparing to care for loved ones or preparing to care and making sure everything is in place for yourself. So let's get started. So the items that we're going to discuss today will be healthcare decision making, financial decision making and management, care planning, long-term care costs, resources, and additional planning. Is my screen not going? Okay. So just to do a quick overview of surrogate decision making, who has the authority to make healthcare and financial decisions? So first and foremost, the person that has the decision making authority is the patient, as long as they're not incapacitated. So everyone essentially has the presumption of having capacity unless they're showing signs of not understanding, not being able to communicate. Maybe they are in a coma. So then, of course, they wouldn't have the necessary capacity. And next is the agent under a power of attorney. We'll discuss, the different type of power of attorney forms that Illinois has. Next is the surrogate under the Illinois Healthcare Surrogate Act, and we'll discuss that as well. And then the last one is a court-appointed guardian. And we'll kind of go into what guardianship is, how that looks like, the different types of guardianship throughout this presentation as well. Okay. So the types of power of attorney. So there are two types of power of attorney. There's a healthcare power of attorney. There's also a property power of attorney. Healthcare deals with medical decisions. It allows a person to make any and all medical decisions for their principal. Sometimes the power of attorney for healthcare specifies different requests that a principal may have. The principal is the individual that is appointing someone, and then the agent is the person that has been appointed. And this person is legally obligated to act on that principal's behalf. Then the next type of power of attorney is power of attorney for property. This power of attorney for property, or the agent, manages and accesses the principal's property. They handle real and personal property. So real property is a home, um, any investment property that this person may have. Personal property is tangible personal property. So there are items in the home, cars, bank accounts, also businesses. If the person owns a business, and that person that they appoint as their power of attorney for property can also manage that as well. So in order to enter into these type of documents or power of attorneys, you have to have a certain legal capacity to execute them. So whenever I talk with clients, I always kind of sit back, talk, ask certain questions to decide whether or not they may have the capacity at that time, and whether or not I am able to produce and prepare those documents for them to execute. And the way you kind of determine whether or not they have capacity, you want to understand and see if that person can understand the nature and effect of the document and the transaction. Can they understand the consequences of entering into this document? Are they going to be able to understand what that this person is going to be over their affairs if something were to happen? And do they trust this person to act in their best interest if they were to appoint them as their agent? That's always something to consider. Are they being coerced into appointing this person as their agent? Do they have the capacity at that time, or are they being unduly influenced to appoint this person as their agent. There are certain different things that you think about when you, or when I, or you have an attorney, work with you to prepare these documents and talk with you. So, healthcare decision making. So, the power of attorney for healthcare, like I stated before, is the document that you, as the principal, would appoint an agent to handle medical decisions on your behalf. So, but I'm sorry, I think there's someone in the waiting room. So you can only appoint one person under the statutory form, but you can also specify successor agents. So you can specify up to two successor agents under the power of attorney for healthcare form. It can be revoked, and it can be revoked without capacity. So you don't necessarily have to have capacity to revoke it, which can be kind of challenging at times. But you cannot amend it if you do not have capacity. You still have to have capacity to change the power of attorney for healthcare form. And then also something to point out is if you sign a new POA, the original POA for healthcare is revoked. And then also there are different things that can be specified as to when the healthcare POA goes into effect. Does it go into effect immediately or does it spring into action? Meaning, is there a certain qualifying event that has to take place in order for this POA to go into effect? Sometimes there's an option of this power of attorney for healthcare will only go into effect when I become incapacitated. I no longer have the capacity to make decisions on my own, and a physician has certified that I no longer have the capacity to make healthcare decisions. Um, or it can go into effect as soon as you execute the document. But this also does not stop you from still being able to make decisions on your behalf, even though you have an agent already in effect. So let's say you have a parent, and they want you to start now to assist with making decisions. That parent can still make their own health care decisions as long as they have the capacity to do so, and you can also assist. That would be that it would go into effect immediately. Only time it doesn't is, like I said previously, is if it goes into effect when the person becomes incapacitated. And then also another thing to briefly kind of speak to effective, it can go into effect at those 2 points in time. And then when is it not in effect? A lot of times it may not go into effect. It may terminate when that person passes away, or you can specify when you want it to terminate. You can put a particular date if for some reason you want it to term only last for a certain particular amount of time. Or if, let's say, at one point you were incapacitated, you had a stroke, and you were determined, it was determined that you couldn't make decisions for yourself anymore. But then you got better and now you can make decisions for yourself. So now the POA is no longer needed at that point. So a physician will determine, oh, you have all your faculties. You can now start back making healthcare decisions. So that agent that was acting at that one point no longer needs to act. So the POA for healthcare can be customized to the principal's values when it speaks to medical treatment, life-sustaining treatment. And then sometimes, you may have more than one child. Your agent may not be your child. Um, and you want them to be consulted before any major decisions are made. That can also be specified in your POA. Um, And then also, you always want to act as an agent, you always want to act in the principal's best interest. So you want to do what the principal would have wanted you to do, unless it could cause them harm, and it would not be the best course of action for them. So you always have the duty to act in that principal's best care. The Healthcare Surrogate Act. So in Illinois, the Healthcare Surrogate Act defines the circumstances under which private decisions by patients who have decisional capacity and a surrogate decision makers can make medical treatment decisions or terminate life-sustaining treatment without judicial involvement of any kind. So this means that there may not be a POA, there may not be a guardian appointed, but you need to have, and you can't make decisions on your own. So what is decisional capacity? Essentially, decisional capacity is pretty much, does this person have the ability to understand the nature of a decision, the potential consequences of that decision, and to communicate their choice? If they do not have decisional capacity, they cannot make these either life life sustaining treatment decisions, or they can't make medical treatment decisions. So then that's when someone has to step in. And if there isn't a guardian or anyone else appointed at that point via POA, then the Healthcare Surrogate Act would need to come into play. So here is a hierarchy of decisions makers per the Healthcare Surrogate Act. So first is the patient's guardian of the person. This is a person that's been appointed by a court, saying that this person is going to make any and all healthcare decisions for that person. So let's say there's no guardian appointed. So next that goes to the person's spouse, if they're married. If they're not married, then it goes to their adult children if they have any. If there aren't any children, there's no spouse, there's no guardian, and next goes to that person's parent. If there's no parents alive at that point, then it can go to their adult sibling, maybe an adult grandchild if there's no adult siblings. A close friend is next, and then the patient's guardian of the state. And this is a person that's appointed to handle all financial aspects for that person by a court. So let's talk about guardianship. I know we've gone over a few things. We've gone on the surrogate decision making. We've gone over POA for property and healthcare. So what happens when you do not have a power of attorney for healthcare or property appointed, but this person needs someone to make decisions for them? That's when a guardianship comes into place. Now you have to go to court and you have to ask the court to appoint someone to make these decisions, or appoint somebody to assist you with your finances. And that's when the guardian of the person and the guardian of the state comes into place. So the guardian of the person is for healthcare decisions. They can make decisions regarding medical treatment, end of life decisions, medical providers, placement, location and contracts, caregiver services, and the list kind of goes on from there. This person is monitored by the court. They have to do an annual report to the court, providing the court with an update on the ward, who is the person that has a guardian appointed for them. And it's kind of monitored if they want to move them. Let's say this person is living at home, but for some reason they need to be moved to a nursing facility. They would have to ask the court permission to move that person to a nursing facility because the level of care has changed. The next type of guardian is the guardian of the state. This person manages finances, they pay the bills, they pay for care of the ward, and they provide personal items. So, with the guardian of the estate, this person is handling financial decisions. If the person has a business, they are kind of, assisting with that business to figure out the best course of action for that business. And this is also supervised by the court. So with the guardian of the estate, they have to account to the court of how these funds, how the ward's funds are being utilized, what they're paying for. They have to get court approval for a budget. So everything as far as guardian of the estate and guardian of the person is monitored by the court. And things have to be approved by the court before the guardian can move forward. So the benefits a little bit of a power of attorney for healthcare and a power of attorney for property is not monitored by the court unless there is an issue that arises and is brought before the court. Guardian of the person and guardian of the state is, you have to be appointed by a court, and it's monitored by the court from beginning to end. So there are two types of guardianship. So we have the guardian of the person and guardian of the state. But sometimes what you'll see is you might see an emergency or a temporary guardian, or you may have a plenary guardian. So the plenary guardian is the permanent guardian. The court has appointed this person to permanently act as this person's guardian to make either health care or financial decisions. And then also something to point out, the same person doesn't have to be the guardian of the person. The same person doesn't have to be the guardian of the state. They can be two different people. Sometimes you may see a bank be the guardian of the state to handle finances. Kind of a lot of times it depends on if it's a contested matter, or and sometimes if there's a lot of funds, um, or the ward has a lot of assets, and the court feels like a corporate fiduciary would be better to handle and manage those funds. A guardian of the person can be a family member. Um, it could be the state, the guardian of the office of the public guardian may sometimes step in to be the guardian of the person. Also, sometimes there's the care management company. Sometimes there may be someone that steps in to be the guardian of the person from there in that capacity. It kind of differs. It depends on the person's situation. But sometimes you have to go in and you also have to get a temporary guardianship. This means that this person is the guardian temporarily and their powers are limited pursuant to a court order, and the order will lay out what powers that they have and how long it will last. Um, so that sometimes will go into play. Let's say mom is in the hospital and she needs to be moved to a nursing facility, but there needs to be a guardian appointed for her ASAP. So you would have to speak with the attorney. The attorney will prepare the necessary petition to have a plenary guardian appointed, but then also do an emergency motion to have a temporary guardian appointed so that mom can have a guardian ASAP to handle the move and make decisions for her for that move, or also get the necessary funds from her account to pay for the nursing facility. That's kind of when an emergency and temporary guardianship comes into play. While you're waiting for this permanent guardianship, which has full powers as agreed upon by the court to be established. So how do you determine whether or not a guardianship is needed? Does a person um, have total capability to make decisions of themselves? Then maybe they don't need a guardian. But is their decision making totally and partially um, declined? Are they incapable of making personal or financial decisions? If so, then they need a report on physician form filled out by a physician that speaks to this. And this form will lay out whether or not the physician believes they're totally and partially incapable of making financial or healthcare decisions. It will say whether or not they need a limited guardian, or maybe they need a plenary guardian um, with full powers. Or if they need to be at a nursing facility, if they need 24-hour care, the physician will need to specify that on the report that they receive. Have they not, Another time a guardianship is needed is if they have not previously designated a decision maker through estate plan documents. And this kind of brings us back to the POA, the power of attorney for healthcare and the power of attorney for property. In some cases, sometimes I'll see that a person may have a power of attorney for healthcare, but they don't have a power of attorney for property. So that looks like now we just have to go into court for guardian of the estate and not necessarily guardian of the person and estate, because there's a POA for healthcare that and that agent can step in and handle decisions for medical decisions, but they can't step in and handle decisions for finances. Another time guardianship is needed is when there's an issue of whether or not the estate plan documents are valid. Sometimes I'll see that some people have decided to download forms off of the internet and they have prepared POAs on their own behalf. And sometimes that becomes an issue within itself. Because if they've prepared a POA on their own behalf, the state has certain requirements for power of attorney forms. So that there's a difference between how a power of attorney form for healthcare needs to be executed, and there's a different way for how power of attorney for property needs to be executed. And one of those things that I'll just point out is a POA for property, you have to have a notary, has to be notarized, whereas the POA for healthcare does not need to be notarized. So it could be you have it signed, but the POA is not notarized. So now that document is not valid and cannot be used. So that's when a guardianship may be needed. Another time a guardianship may be needed is if there are POAs in place for healthcare and property, but the agent is not acting in that principal's best interest. Maybe they're misappropriating funds, maybe they're not making sound medical decisions for the person, and it becomes a concern. So someone at this point has decided that this needs to be brought to the court, and a guardian needs to be appointed, and those power of attorney forms need to be revoked, suspended, um, or sometimes invalidated depending on the circumstances. That's when a guardianship would come into play. And then also when there's conflict between parties, when individuals who are family members cannot agree on the next course of action if they have been appointed, or if they haven't been appointed, there's no guardian. So let's kind of go over guardian of the person, powers and duties. And I've kind of spoken to this a little bit, but we can go into it a little bit more. So they have custody of the ward's minor and adult dependent children. They have authority to choose the ward's placement, to place the ward in a residential facility with the court's approval. That's something important. Like I stated before, you always have to have court approval when making major decisions because the level of standard of care has changed. You have to have the right to control who and cannot visit the ward. With POAs, this is kind of um, you, you don't have the full power to really control that. So sometimes you will see someone that has power of attorney have to go into court to have a guardianship established. And sometimes you may determine as the guardian or the POA that this person um, is detrimental to the ward and they should not be around that and visit the ward. Um, due to their health. And that's sometimes a call that you have to make, and the guardian of the person has that control to make it as long as it's in the best interest. And if it's brought before the court, it's demonstrated that this was made in the best interest for the ward. You also have the duty to make provisions for their support, care, comfort, health, education, maintenance, and professional services. So you also want to meet with the nursing staff and then at the nursing facility about a care plan and making sure that the ward is receiving all the services that they need in order to, one, either maybe get better or to help them as um, while they're there in their stay, and also help them have a good time and possibly be open to participate in activities at the nursing facility because it's a difficult thing to go from living in your home to now living in a facility, and you want to make sure that that individual has the support that they need when they make that transition. And then they also have all the rights of a surrogate under the Healthcare Surrogate Act to make decisions to forego, withdraw life-sustaining treatment. So, guardian of the state. So, like I stated previously, the guardian of the state handles financial um, decisions in the assets belonging to the ward. So, they are over the care management and investment of the ward's estate. For certain investments that needs to be made, you have to get court approval. This is also supervised heavily by the court. You have the authority to disperse the ward's funds with court approval, comfort and support of ward minor children, adult dependent children, and a spouse. You want to exercise any and all powers over the estate and business affairs of ward that the ward could exercise if not under a disability. You'll appear for and represent the ward in the legal proceedings if they're being sued or for some reason they became incapacitated due to an injury from a job or a car accident. You can get court approval to move forward with a lawsuit um, to recover for damages to that person. You can engage in estate planning for the ward, but that's also a process and has to be approved by the court as well. You have the duty to carry out the ward's wishes as best as they can be ascertained. And you also have to file annual accountings to the court each year. So this means you have to account for any and all disbursements, receipts um, that come into the guardianship account each year and kind of give an overview of where the assets stand. Have they decreased? Have they increased? Have there been new assets acquired? You have to account for all of it, and it has to be approved by the court. Financial decision making and management. So, power of attorney for property, you have to have contractual capacity to execute, and it also requires contractual capacity to revoke. So, once a principal becomes incapacitated, the principal no longer has that capacity to change their power of attorney forms. So, next, The powers of the agent are defined in statute are very broad, and unless the POA has been modified to include certain provisions, you cannot do it. So let's say, for instance, you cannot gift yourself or make yourself a beneficiary on any of the principal accounts unless the power of attorney for property states it. If you do not have language that speaks to it, you cannot do it. If you gift yourself or make yourself a beneficiary, that is self-dealing, and that is not something that you can do. So power of attorney of property can become effective upon the date of signing, so it become effective immediately. That does not stop the principal from still being able to make decisions for themselves if they have the capacity to do so. They do not have the capacity, they cannot make decisions. Um, or it can go into effect when the physician has stated that the person is incapacitated. So if the document was executed during a period when the principal lacked capacity, they can be challenged, and this is when you will also see it being brought to court and asking for a guardian of the estate appointed, and the court can review the circumstances and any possible evidence that's being presented to demonstrate that this person did not have the capacity to sign off on this power of attorney for property, and the court can invalidate it, meaning that the power of attorney no longer stands. And then at that point, the court will work towards having a guardian appointed. So wills. So a last will and testament is a document that is prepared and put together that speaks to what you want to happen to your assets when you pass away. This can speak to you can either say sometimes you'll have a last will and testament, sometimes, and you will also have a trust. You could say that I want my assets to go to my trust at the time of my death. You can say you want this to go to your brother, your child, your spouse. You pretty much specify what you want to happen to your assets under a last will and testament. But also something to keep in mind, if you only have a last will and testament, this the will has to be probated in court unless your assets are under, as of I believe August of 2025, if you pass away after August of 2025, um, if your assets are under $150,000, you can use a small estate affidavit, and you would have to include your last will and testament that speaks to how your assets should be dispersed. If not, then you have to go through probate court to have your estate administered. So joint tenancy. So a form of joint ownership where each person owns 100% of the property. At the time of death, one joint owner um, will get 100% of the property and own it entirely. So let's say you have four people, um, let's say you have four people on an account. As each person passes away, the last person standing will retain that full account, or even for a property. Let's say you own the property as joint tenants with a right of survivorship. When the last person, so it's maybe four people on the property, the first three people pass away, the last person standing is the one that will own it. So the advantage is there's no cost to set it up when this is with your bank account. It avoids probate. And then also arranges the state so that they will be able to handle financial affairs during incapacity. Um, so you wouldn't have to get court approval to access the account if you're already on that account. However, there are some disadvantages. It's risky. Joint tenancy opens you up to that other person's creditors. So let's say that mom has an account and she decides to add her daughter onto the account, but the daughter is sued. This account is looked at as hers, and the creditors are open to try to go after it. So now but the daughter was only put on for convenience purposes. So technically, all these funds are mom. Now, this has opened mom up to having some of her funds being taken. It does not allow for contingent beneficiaries. So if the joint tenant predeceases you, you cannot add you cannot add additional beneficiaries on. So essentially, you have two owners on the account. You can't add on if something happens to both of you, this is what's going to happen next. So once you become the sole owner of that account, then that other individual will need to be removed. And at that time, you should be able to add contingent beneficiaries, but not while there are two joint owners on the account. The surviving joint owner is entitled to entire property at the death of a joint tenant. And then also for Medicaid applicant, is presumed to be 100% owner of all personal joint property, which could be a problem when a person needs to become Medicaid eligible if they're in a nursing home. And if they're a joint owner, then this asset is viewed as 100% theirs instead of and not 50% theirs, which could be problematic. So let's talk about trust. What is a trust? A trust is a legal arrangement through which one person or institution holds legal title to property for another person. The rules and instructions under which the trustee operate are set out in the trust. So there are different types of trust. It can be a revocable trust or irrevocable trust. One, a revocable trust, let me go to the next slide, let me not get ahead of myself. A revocable trust gives the donor complete control over the trust. And then you can also come and you can make changes to the trust terms. And you can also take back the funds once they're put in. So a revocable trust is used for asset management. It allows the trustee to administer and invest the trust property for the benefit of one or more beneficiaries of the trust. It avoids probate. So instead of having to go through a court at the time of the person's death or the trustee's or the grantor's death, who is also the grantor is the person who establishes the trust. The property will pass outside of probate court. So the people that are mentioned or the beneficiaries of the trust could receive those funds outside of probate court as long as the trust has been funded. Also, it's used for tax planning purposes. The trust can be drafted so the assets will not be included in the estate of the beneficiaries, which avoids taxes when they die. And also disability planning. So unlike a will does not speak to what would happen to you if you become incapacitated, but a trust can. The trust can lay out guidelines and what you'd want to happen if you become incapacitated. So something also to keep in mind is that sometimes individuals who have been adjudicated incompetent by a court may still have the testamentary capacity to make decisions, um, to execute and amend or revoke their trust. So testamentary capacity refers to the mental ability to make or change a will. So an individual must understand that, or even a trust in this aspect, they must understand that they are making a will or they're making a trust, and that the nature and extent of their property, and they also have to understand the potential changes that they are making in the relationship to the beneficiaries. And then it can be established by the principal's agent under power of attorney for property. And if that specific power is granted in the POA document, you would need to specify certain powers that you want this POA to have, and also gifting. So if, for instance, the power of attorney needs to make a gift, they have that power to do it, and it has to be specified in the POA document. When an individual under guardianship lacks testamentary capacity, the court may authorize the guardian to engage in estate planning on behalf of the individual. And that is a process. Sometimes the court has to, one, establish if this estate plan would be what that ward would have wanted to take place. So they have a hearing that's typically called a Howe hearing. And during this Howe hearing, you would put forth certain documentation or testimony to show like this is the plan that the ward would have set up for themselves if they had the testamentary capacity. Duties of the trustee. One, you would have to prudently invest and administer trust assets. You have a loyalty to trust beneficiaries, no self-dealing, so no gifting to yourself. Um, Also, you have to account to trust beneficiaries and you have to comply with the terms of the trust. So there are a few disadvantages. It's more expensive to create a trust, so there are higher legal fees. The assets may be transferred to the trust, which can be very time consuming. And I spoke to funding the trust. The trust has to be funded, meaning that you may have to change the title on accounts to the trust name. You may have to make the trust the beneficiary of certain accounts. If you own real property, you would have to deed the property into the trust so that the trust is properly funded. If a trust is not funded, it serves no purpose. So also assets must be held in the trust and they require lifetime administration sometimes, depending on the terms of the trust. The trustee has authority over trust assets and is limited by the terms of the document. They can't do what they want. They have to follow the terms of the trust. The irrevocable trust cannot be changed or amended by the donor. The donor is the person, and I'm sorry if I didn't specify this earlier, but the donor is the person that made the trust. So once this trust is set up and executed, it cannot be changed. Any property placed in the trust may only be distributed by the trustee as provided by the trust itself. For instance, the donor may set up a trust under which they will receive income earned on the trust property, but the trust bars access to the trust principal. So, and the trustee is bound by those terms. A testamentary trust. This type of trust is created by a will. So, in a will, it will specify that when this person passed away, this type of trust must be um, it will set out the terms of the trust typically in the will, so you don't have to have a separate trust document. And that person will usually the executor is usually the trustee as well. And this person, once the estate has been probated, will go into this testamentary trust, those proceeds, and it will be dispersed or handled pursuant to those terms of the trust. Um, and so typically this testamentary trust does not have any power until the will is probated by the court. It is, like I said, it has to be probated by the court, so it does not avoid court. It also will become a public document because the will is filed with the court. But it can be helpful when you try to establish estate planning goals, especially if you have a disabled spouse. So another type of trust is a special needs trust. And then kind of speaking to a special, like the testamentary trust. So let's say if you had a disabled spouse, that testamentary trust, which would be a part of your will, would be a special needs trust set up for your spouse if you were to predecease your spouse who is disabled. And those terms would need to be followed. And of course, it would be probated first. So a special needs trust can also, is often known as an Oprah trust. It would be a first party trust, meaning that sometimes it's funded by your own, it's funded by your own funds. A third party trust, special needs trust, is funded by someone else's funds. It can be used to assist a person who is or may become eligible for Social Security or Medicaid. It can be established by the individual, which, like I said, is the first party trust. That means that it's funded by your own personal funds, a parent, grandparent, or guardian, or by court order. If it's funded by the parent or the grandparent with their funds, it's considered a third party special needs trust. And most special needs trusts are irrevocable. Irrevocable. There are two types for people under 65 years old and disabled, and people over 65 years old. Care planning. Make sure I have, okay. Care planning. So there is a practitioner's order for life-sustaining treatment. This is a revised version of a DNR. It's a medical order reflecting a person's wish that travels with the person across settings of care that must be honored by all healthcare providers. It's intended for people who are seriously ill or have life-limiting illnesses. It's completed after a patient discusses their preferences with healthcare professionals as to what they would want to happen if they are in a situation where it's being determined whether or not they should receive life sustaining treatment or if they should not. And it has to be signed by the patient or a patient representative and a qualified healthcare practitioner, which is typically a physician, licensed resident, advanced practice nurse, or physician's assistant. So typically, when we prepare estate planning documents, we also include five wishes. So the five wishes is an advance directive form that can be legally used in 42 states. It's pretty much a document where you can provide direction on how you want certain things to transpire as far as your personal, spiritual, medical, and legal wishes. I've had someone want particular direction for their pets when they passed away or if they became incapacitated. So they put that information in their five wishes, how they wanted their cat to be cared for, who they wanted to receive their cat. So that is something that can go in the five wishes. It's written in everyday language and includes instructions on how to complete it. So it's it's also, I believe they also have a website as well where it can be downloaded and utilized. But if we prepare your estate planning documents with my firm, we typically provide it as well. And then it also is important because sometimes what I'll see when I practice or have guardianships or someone has passed away, sometimes people do not communicate their wishes with their loved ones. And that becomes problematic because sometimes you just don't know what your loved one would want you to do. And the five wishes helps with that because you are able to write out what you would want to happen, so that your family or your caregiver knows exactly what you want. And it's legally valid in most states. So, long term care costs. So, what is long term care? It's medical and non medical care given to people who are unable to perform basic activities of daily living. It can be provided at home, in the community, or in long term settings like assisted living or skilled nursing homes. Sometimes if you may need it at any age. It's not for a particular age. Let's say someone becomes incapacitated at 25 or 45. You don't have, there's no age requirement there. May, Medicare and most health insurance plans do not pay for long-term care. So Medicare covers up to 100 days of skilled nursing care provided in a Medicare certified nursing facility. This only happens though when a person has been hospitalized in person for 3 nights. And it will pay the full cost for the first 20 days. After the first 20 days, the co-insurance payment for days 21 through 100 kind of goes into effect, which sometimes can also be covered by Medicare supplemental policies. It provides home care to those who need skilled care, usually post-hospitalization only, although long-term, part-time skilled home care services are covered. Skilled care does not include custodial care, which is a type of long-term care most individuals impaired by dementia require. So long-term care insurance is the only health insurance that pays for custodial long-term care, either at home or in a formal care center. So there are some provisions to look for and consider. So you want to make sure you look for combined long-term care and life insurance, premium waivers post-claim, fixed premiums, spousal portability, max daily benefit and max lifetime benefit, home care benefits, and manager benefits when you are looking towards long-term care insurance. So Medicaid, there is a federal and a state program. It's monitored under federal law and state law. So the state law has regulations and policies. The Medicaid agency for Illinois is the Illinois Department of Healthcare and Family Services. And state eligibility determinations are determined by the Illinois Department of Human Services. So if you are in Illinois and a Medicaid application needs to be prepared, it will be go through HFS. And Medicaid also, it works for long-term care for nursing homes. It also provides sometimes care for supported living, community care programs, and in-home services, depending on your age. And that is the end of my presentation.